Okay, we're here to do another show of Sovereign or Slave, and today we're going to delve into foreclosure issues once again. And today I have a guest with me who does mortgage lending, and he's familiar with the lending process. And we're going to talk about securitization. And securitization is a process that is fairly recent in history, because I don't believe that before 1990 that they were doing securitizations, but I'm probably wrong, and so we are going to talk to Mr. Oaktice.
Well, Jeff, thank you very much for that wonderful introduction, and I really appreciate that. I hope, and I look forward to useful presentation and make sure that we covered basics on the mortgage lending. That includes the securitization issues. So having said that, and
where does it all start, Oak?
Well, that's a very good question. It started in the 80s, but securitization has always been part of the mortgage lending processes. But what happened is that recently what you heard about securitization, fraud, and other things that is going on right now is that the people who got into the securitization business, I believe they had gotten too greedy in the process. Securitization process is a very good and useful process if it is done correctly, because you're tapping into the source of funds. The more money comes in and the more loans can be made and enable the homeowners to purchase properties.
Well, let's discuss what happens initially when Bob and Mary come in to buy a home. The first thing they do would be what?
Well, I think maybe I should explain that in a very simple terms, going back to the way it was. Husband and wife, and if they wanted to buy a house, and they identified the property, and then they said, well, okay, we need to purchase it at a certain price, and we need a loan of X number of dollars. And they would normally go to the local bank and sit down with them, and this is going back to like 50 years or so, and the banker would look at them and analyze their financial situations and look at their character, capacity, and their credit ratings and ability to repay the loan. Look at their income,
and the
expenses.
Common down payment at that time was 20%.
The down payment was 20%, but you could buy a home with 5% down, FHA, and
50 years ago.
You could do that, yeah. And but there were safeguards at that time. So the banker, because they're local, because they know you, I believe they used to be called unit banking system. So you get your loan, and then you sign a note to the bank, and the bank keeps the note in their vaults. That's their money. Now, of course, it is a little bit more complicated than that, but let's just say that it was their money. Mm-hmm. But they're the instruments of making these loans. But they used to keep the note in their possessions.
My father-in-law got his original note back when he paid off his house.
That's right. And then you tell the banker, and you say, well, look, we need to borrow this money. I will pay you back. And when I pay you back completely, in full, you give me my note back, I own my home.
Otherwise, the note is like an IOU, and if he still keeps it, he can ask you to pay it.
Exactly. And then, in addition to that, we give the bank a another security instrument called a deed of trust, that if I don't pay you back, you can take the property back and sell it, recover your money. That's just the way it was. It's a real simple system.
Right.
But eventually, I don't want to sound bad on Wall Street people, but unfortunately they did real bad. They got into this act and figured out, well, you know, why should we use the unit banking system and individuals go to the bank and borrow the money and buy their homes, and this is a very cumbersome system. Had they not gotten too greedy about this. So they found a way, which I can get into details on this, to create a pool, and they sold slices of interest in this pool to all kinds of investors, local or foreign investors. Pension funds and many other institutions bought into this.
So the pool would have 1,000 mortgages in it?
No, pool basically was organized to keep money in there. It's just like your swimming pool. Instead of water, you got a bunch of money in there. It could be $100 million, it could be $1 billion, $5 billion, whatever it is. It was determined by the entity formed this pool, namely, like, for example, Goldman Sachs, Merrill Lynch, and other Wall Street institutions.
Well, was the money that was invested into the pool varied and comes from different sources, or did it all come from mortgages?
The pool was formed for the purpose of mortgages, used for that mortgage, getting mortgages. But if you can imagine a blind pool, let's just say no mortgages there, but they started this pool called XYZ pool, and then they said that the pool is going to be capitalized at let's just say $2 billion, and then they issued 10,000 certificates, and they categorize each one of them.
So they're shares.
They're shares. And then they sold each individual ones, and then the entity formed this pool said to them, to the investors, that your return will be 5%, 6%, pretty well guaranteed. But the sinister part of this event was that in most cases, the organizers forming these pools, they knew the pool was going to fail, or they made it that way. And then they took insurance against the default. From AIG, for example, is a very good example of that.
They were the biggest insurers, right?
They're the biggest insurance company in the United States, among other insurance companies. So they took insurance against that. But the other thing they did is they grade the pool, credit rating, for example, from the agencies, Moody's and Fitch and others. So there's a wrongdoing, apparently a wrongdoing there as well, that when the insurance company knew or should have known that this pool was really designed to fail, but they gave it AAA rating. So it enabled the...
even though the Goldman Sachs was betting by insuring it, because they didn't feel comfortable with it, that they insured it so that if it did fail, they would get their insurance back.
They would get their money back.
Right.
They knew it was going to fail. And if you really get into the details of this, that many of the pools were designed to fail. Now, I want to emphasize
they were designed to fail because they were collections of very badly written mortgage
Well, the
agreements.
underwriting guidelines were very loose. For example, you could a borrower could go and get a 100% loan. Now, with a real bad credit rating.
Right.
Now, you're not going to the bank in a traditional sense to borrow the money, where the banker looks at you and then grades you based on your credit rating, your income, the real income. But the pools where the underwriting guidelines were specified in their documents, their either prospectus or the pooling and servicing agreements.
In other words, some loans would be given out at where the borrower, they're fudging his income. I mean, you know, when they apply for it, they know that he doesn't have the kind of income, and yet they put false numbers in there anyway. And so they would have to, that with, you know, poor history, credit history, and all these other issues, they must somehow have marked those loans as being, you know, designed to fail.
Well, that's true. For example, the underwriting guidelines, one of them, several of them really, were based on the credit rating of the borrower, for example. If your credit rating, for example, is over 650 FICO score, or I'm just making up this number, or maybe 700, then they allowed the borrowers to state their income and assets. I have seen dozens of cases where we look at the borrower, there's no way they could make $30,000 a month income. They're making $3,500 a month income. But because they had a good credit rating, in order to qualify them for that mortgage, so you state their income at $30,000 a month. Unbelievable. There's nobody could believe that, but it was within the underwriting guidelines. So, having been a mortgage broker, I've seen many cases that you had to state their income, and we this is another issue that we expressed our opinions to the underwriters at the bank's level, saying that these people do not qualify. But because of the programs and because they were under enormous pressure to push these loans, they directed us to state their income, and in many cases that they suggested certain sums of money that they should be documented in their 1003 application forms so that they would qualify.
And they were going to fail. Is there any reason why they would do that? I mean, there has to be some kind of financial benefit for them.
The reason for that was that the pool was already sold out, and they have $3 billion or whatever enormous amount of money in there that needed to be used for these mortgages. So they were pushing the money out to make loans as fast as they can, as many of them as they can, irregardless of the outcome, because they already have an insurance.
Okay, and where does this money get created from? I mean,
well, the money,
where does it originate from?
The money came from the investors that they sold these certificates to. It could be hundreds of people or thousands of people overseas. You heard a case in Iceland, and I believe they went bankrupt, or they were really in financial problems, and they were pretty heavily invested in these mortgage-backed securities, which turned out to be real bad. But the problem is, this is extremely complex. Although it's a very simple process, but it's very complex in the way that they have formed this and utilized the processes to originate loans that they were, I would say, fraudulent to start with.
Well, let's start with, you know, Bob and Mary come into the office and they've decided to pick out a home, and they sign up a loan application originally. And then their loan application gets looked over and approved?
Well, they were looked over and approved based on these exotic mortgage programs.
Okay, so then let's say they get their loan application approved. Who does it get submitted to?
No, you're talking about the origination process, mortgage processing. Is that what you
after you go through the loan application?
Well,
the application gets submitted to somebody, right? Who?
Well, the application is filled out, which is called a 1003 application form. It's a Fannie Mae form. It's a government originated form. It's a very good form, by the way. It has a lot of information that really tells you about the borrower. But you can put any information you want in there unless it is verified. And many of these were not verified. For example,
well, they would be filled out by the person borrowing or the person helping them to secure the loan?
The borrowers, I would say over 95% of the times, did not or were not willing to fill out these applications
So
themselves.
They weren't going to lie about their...
They weren't. The mortgage broker, I filled out their applications in many cases in their presence. You know, we asked them, because when you have a form that they're not familiar with, it's very difficult to fill out with it. Somebody has to guide them through. And I would ask them their names and addresses, you know, we fill it out. And then when it comes to the income section, what is your income? Where is your W-2 forms and pay stubs? And we look at it. You know, it's all documented. You fill it out. As far as their assets and liabilities, you know, you run their credit reports. And these softwares that we had, when you run the credit report, all their liabilities are automatically filled in this application form. It's already pre-filled. So the softwares were very sophisticated. You can fill out all the information while you're interviewing the applicant. It will automatically fill in the areas.
So they authorize a credit report, and then the credit report gives the information to the software, and the software just fills the form out.
Fills it out. It's very easy to do. But then you review it with the borrower, and you give them copies, and they take it home, they review it, and they sign it, and then bring it back. And they didn't have to. They should sign them, but they always sign them at the closing, you know. But we had forms and authorization forms, you know, it's all authorized to run their credit report and then fill out the applications and so on. But the problem area was on the assets, liquid assets sides, how much money they have in the bank, what their income was. Well, that's where it's stated. It was allowed. The programs that the Wall Street people already designed allowed stated income, stated asset programs, or no income, no asset programs. So how do you feel? What do you do? And you look at the loan amount they're getting, and then there are some ratios. They call them front ratios and back ratios. Like you have the mortgage payment, principal, interest, you know, taxes, insurance. It should be within a certain ratio of your total income.
Yeah, it used to be 25%, and then they boosted
28%
to like 35% and 40%.
Well, if you look at their real income and you look at the front ratio, it may come up to 60%. These people do not qualify for this loan. But because of the pressure, because of the availability of these programs designed to fail, stated income, so what income should they have to bring that ratio down to 28%? You know, simple calculations, and you find that maybe they need to make $9,000 a month income. So you put in $9,000 a month income. Now, is this a fraud? Is this what? Well, it's a wrong information, but it was allowed. This
Right.
was the
It's
program.
it's within the guidelines.
Within the guidelines. And many times that we call the underwriters of the lender and say, these people have, they don't have enough income, so what do we do? What? Well, many times they would calculate the income and say, well, put in $9,500 or whatever. Or sometimes that we send the documents over to them and they would correct it and send it back to us, so we would redo it.
So, but they've come and they've filled out the loan application, and now they are sending that application off to the bank or to a broker who's going to submit it to an originator who's going to provide the funds, and who's providing the funds?
Well, it's not only one application form you fill out. There are many other forms that's filled out. Authorization form and credit reports, the 1003 form, 1008, the underwriting transmittal forms. There's a lot of them, disclosures and so on. They're all packaged together, and the borrower always sign the 4506T form
for tax returns.
For tax returns, that gives the lender the authorization to get their actual income from the IRS. But the lenders did not, many cases, did not follow up on that because it was stated income, even though there was a 4506T form. So the whole entire package went to the underwriters at the lender's level.
And the lenders are Wells Fargo,
They're
Bank
originators,
of America,
Wells
Countrywide,
Fargo, Countrywide, yes.
Big players that are doing. How many big players are there like that? Like under 10?
Well, I would say so, under 10, or you can count them, let's say. But under that, there are many originators,
And
many
like
mortgage
middlemen.
companies, and they're local mortgage companies. What the lenders, I shouldn't even call them lenders really, because it wasn't their money. They were intermediaries. Wells Fargo, I'm talking about Bank of America,
and Countrywide.
They weren't the lenders. They didn't use their money to loan to the borrowers.
Okay.
But under them, they created enormous amount of sub-lenders. But they're called, these people, they're originators, but they originated the loans and they were table funding the loans. In other words, they were closing the loans on their own names, but using Wells Fargo. The money came from Wells Fargo, which wasn't Wells Fargo's money. They had money somewhere else coming in, and they forward the money to the escrow company, and then they fund the loan. So
where would Wells Fargo get the money to give to their...
From the pool.
From the pool. So Wall Street would create the pool, sell the shares, generate the funds, and then give those funds to the banks.
Right. Just look at it this way. They created the pool. They got a ton of money in there. Now it's got to be used. So then they got the Countrywide, the Wells Fargo, Bank of America, all these big players, and then underneath them the other players. And then the money did not go directly to these people, but it went through warehouse lending processes. They got warehouses. J.P. Morgan Chase, for example, may have another entity there that they warehouse the money. All that money through electronic transfers. If you need to be funding a loan here, it would go from the warehouse line of credit to one of these players, and then the next one, and it goes to escrow, and then the escrow would fund the loan. Now, how would you know that? How would you know where the money is coming from? You sit down and
your belief is that it's coming from Calbay Mortgage, your local lender, who
exactly
you sat in front of the table with them.
That's correct. And the note, you give them a note, it says that I owe X number of dollars to Cal Bay Mortgage. But the title company or the escrow, they had the evidence where that money was coming from. It wasn't coming from Cal Bay. It was coming from another warehouse line of credit somewhere else. This was not disclosed to the borrower. What would have happened if it were disclosed to the borrower?
Then the borrower would want to make his payments to the person who was supplying the money.
I would assume that they would want to question that. They would say, well, where is this money coming from? But perhaps, the borrower, logically speaking, the borrowers, they want the money, they want to buy this house, so why would they question where the money is coming from? 99% of the times, nobody questioned that.
They're only worried where the money's coming from to buy the new drapes they want to put in.
That's right. So Cal Bay is the beneficiary there, for example. You write the note to Cal Bay. Who cares where that money was coming from? So they got it. But the system, the originators of the system, they knew what they were doing. They got the money. They used the money through the channels of the big play, Countrywide, Wells Fargo, and so on. And then they dispersed the money through the available escrow title services and funded the loan. And they got the borrowers to sign the note in the name of the originator. And then the originator took the note and the deed of trust, transferred it over to the seller, like, for example, Bank of America or Wells Fargo. It went over to them, or Countrywide. And then they took all these notes and mortgages, and then they transferred over to another entity they created.
Well, they would have to endorse the note. That's
another issue. You get into the legality of this, but I'm talking about the process. So they transfer these documents, note and the deed of trust. These are the two, along with the others, but those are the two most important documents. Went to the Wells Fargo or B of A. These are the sellers. And then they created another entity, the depositor. They made it bankruptcy remote. And then it went to another entity, the trust, the pool itself, went in there. Now the money went out and then replaced with the note and the deed of trust. Of course, then you get into the agreements. How are these trusts are handled, governed by? There are certain laws that usually the New York trust laws that govern these.
And the trustee for the pool has certain duties and obligations.
There's certain duties, and there's servicers, master servicers, and the others, the servicers, primary servicers. They service the loans. But now, when you really look at this overall situation, if everything went well, everybody was happy, nobody would ask questions, But now things are not as good as expected. So the borrowers are failing to make mortgage payments. There's a lot of default, and these trusts are calling in on their insurance policies. They're getting paid. They're foreclosing on these homeowners,
and
which they already got
went
paid.
Bankrupt in 2008.
And then the government, the public, bailed them out, paying off these mortgages, whereas the borrowers are still making payments, or if they didn't make payments, they're foreclosed upon. And these are sold.
Well, and if the government's going to step in and bail out AIG for issuing insurance to cover the investors who, if you invest in something, isn't that a risk? You're really just giving money to the fat cats who are saying that everything is AAA rated when they should be losing everything they have. If the government's going to bail out anybody, it would be, if you're going to pay off the mortgages, then shouldn't the people that are living in the houses keep them? I mean, why should you pay off the insurance policy on the homeowner not making the payment to the benefit of the person who was taking a gamble that the stock they were buying was going to pay off, rather than the homeowner who is, his gamble was that he would keep his job and be able to make his payments?
Well, that is true, what you're saying. This is where the legal issues come in right now. And to me, what this is, in its simplest terms, is a perfect planning of a perfect crime. Is it a criminal act? I'm not a lawyer. Of course, I don't want to be judgmental on this thing here. But
I'm just offering spiritual advice.
No
legal advice here.
When you're looking at, if you have a mortgage situation and then the Wall Street firms or the trust got paid through insurance, should that not be credited to the benefit of the homeowners?
Right.
It should be.
Well, and oftentimes the homeowner, if they weren't putting 20% down, they had to pay mortgage insurance.
That's right.
So if you're paying insurance, you don't insure somebody else, you only insure yourself.
But these were all created for the benefit of the lenders. Now, when I say lenders, well, they're not the real lenders anyway. It wasn't their money. The real lenders really are the certificate holders, the investors who funded these pools. Now, there are thousands and maybe millions of them that they have a little slice of your mortgage or my mortgage. How are they going to foreclose on me? I don't pay that small amount. See, this is all pre-planned. It's all designed so that maybe is it a plausible deniability?
Absolutely.
That and the Wall Street people could say, well, it wasn't our fault. It's the mortgage broker or it's the other people down the stream, that caused all these fraudulent activities.
Okay, this is an example of the securitization, and would you like to discuss it? Oh,
yes. This one is one of the examples that not only it shows the processes that the loan went through, but also the screw up, I call that. This is a pretty serious situation here. I think eventually that we will get into the position where we will be able to talk about the legality of this thing here, how the court system sees these. I think, Jeff, you will have a lot of other questions about that when we get to that point. But just for the sake of discussion, let's just follow this steps here to see what happened. For example, this loan was originated June 16, 2003, and the lender here is Flagstar Bank, which is one of the originators. Flagstar Bank is not as big as Bank of America or Wells Fargo, but they are originators. It's a bank. So
on the deed of trust, they are listed as the lender.
On the note and the deed of trust, they're listed as the lender.
Okay.
So the note was originated June 16, 2003. The Flagstar Bank is the beneficiary, and of course the homeowner is the borrower.
Borrower / settlor or trustor.
Under the deed of trust, they're the trustor, and also MERS is shown here as the nominee for the beneficiary. Again, this is another issue that is subject matter that could be discussed.
How can Flagstar Bank be the beneficiary and MERS be the nominee?
Well, this is what they did. They created MERS, Mortgage Electronic Registration System. It's nothing more than tracking these mortgages electronically through the maze of these securitization steps. And another example of why or how they deceived the public. Because when the mortgage travels through the securitization process, every time the mortgage or deed of trust has been transferred to somebody else or note is endorsed and sold, they have to be recorded. This process has to be recorded in the county recorder's office. But through MERS...
So if somebody's looking up records, they can find out who is the responsible party at that point.
Correct. But with MERS, you'll never know that. Unless you're a member bank, and then you can look up MERS records, and MERS will show you where the deed of trust is and how it was transferred. But let's just go to the next step. The loan was originated at a local title company or escrow, and then the Flagstar Bank is the lender of record. So it appears that Flagstar Bank funded this loan. What in actuality, this loan was funded through, where it says there, CSFE mortgage-backed pass-through certificates. That is the pool. That pool had so much money in there, and part of that money was used to fund this loan. Did it go to Flagstar Bank? No. It went to the warehouse lender or warehouse lender assigned for the Flagstar Bank, which funded this loan. How do we know this? You have to look at the records of the title company and find out where that money came from, which never, by the way, they never disclose that to you.
So you can request that information from the title company?
You can request that, and they will not give it to you unless you subpoena them or go through the discovery process.
In a court case? In
a court case, correct. Why don't they do that? Well, that was the process. I mean, it didn't matter where that money came from. But again, if you look at the legality of this thing here, and not being a lawyer, of course, I'm just using my own opinion here, is that Flagstar Bank says that I loan you the money. Is it really their money? Where is their record to show me that Flagstar Bank actually loaned the money to the borrower?
And if they didn't loan it, how would they have the right to get it back, collect on it?
That's right. So eventually Flagstar Bank sold or transferred that loan to Washington Mutual. Now where's the evidence? If I go to a county recorder's office, you will only find one item recorded there, is that deed of trust recorded to Flagstar Bank. You'll never find anywhere anything that says that Flagstar Bank transferred this deed of trust to Washington Mutual, unless you go through the MERS records, which is not public. Now, one of these entities, either Flagstar Bank or Washington Mutual, securitized this loan. I suspect that it was the Flagstar Bank. How do I know that? Is because if you look at the cutoff date of the trust, if you go down, you'll find the cutoff date is December 1st, 2003. That's where and then the closing date is December 29, 2003. So based on the pooling and servicing agreement that governs this trust, all these loans would have to be deposited into this trust by the cutoff date, December 1st, but no later than December 29, 2003. And this loan was originated in June 2003, so it took them 6 months, or not 6 months, but whatever, 5 months to get there. The trust...
No, it says more sellers.
You see, here's where the trust, if you look at these items came from the pooling and servicing agreement. If you look at it, you will see that the trustee for this trust is J.P. Morgan Chase. And then you look down, Washington Mutual was one of the servicers. And then down below that, WMMSC, which stands for Washington Mutual Mortgage Securities Corporation, that securitized one of the sellers. Wells Fargo Bank is another seller. And Wells Fargo Bank was the master servicer and also custodian for this trust.
So the custodian would keep the deed of trusts that were submitted to it and the promissory notes.
The original.
And they'd have thousands of them.
Correct. And then Credit Suisse First Boston Securities Corporation, which is CSFB, is the depositor. That is the trust. And the trustee was the JP Morgan Chase. So now, if you look back, you see JP Morgan Chase is the trustee and the servicer. So if you go up a little bit.
How does FDIC come into that?
FDIC got into the act is because Washington Mutual went under. FDIC took over, and FDIC made a deal with JP Morgan Chase, and they sold or transferred all the Washington Mutual assets to the JP Morgan Chase, and that's why FDIC is listed there as another party that is responsible or party of the securitization processes here. Right here, one thing that I want to mention is that the question is, who would be the foreclosing party on this property?
Well, the only one authorized to foreclose is the lender.
And the lender is?
The lender is the person who's named on the deed of trust, which was Flagstar Bank. They are the only ones that are named, and they're the only ones that would be authorized.
That is correct. That is correct. If they loan their money.
Right.
But they're the lender of record based on the note. But
on the deed of trust, they would be the only ones that
could foreclose.
If they had the deed of trust and the note together, then they would be the ones that had the right to foreclose, and no one else but them.
But them. So if this property was to be foreclosed upon, how would that happen?
They would.
But the note now is in the trust, and the deed of trust supposedly there. So the trust owns the note.
Well, it has rights to the note. I doubt that it actually has possession of the note.
Let's assume that they do. They have to, or they're.
Well, then there would have to be an assignment to them, so that they would have the rights, and then they would have to have a chain of title showing that the deed and the promissory note were never separated and that were assigned to them.
Correct. So
and that money transferred hands, they bought it, and then they would retain the right to foreclose.
Foreclose. So in other words, the trust is the owner of the note, assuming that the note was endorsed and properly transferred, and the deed of trust,
yes,
and the deed of trust, they assigned properly and recorded.
Right.
Then, if they want to foreclose, they would assign the deed of trust back to the Flagstar Bank, and then.
Or they would have had to have recorded at the county recorders an assignment, a proper assignment, that they had purchased the note and the deed, and that they were the new lender.
Right, but in other words, Flagstar Bank would have to foreclose on that. But in order for them to foreclose, there has to be some type of a substitution of trustee from the trust to Flagstar Bank. And then Flagstar Bank would foreclose through MERS. MERS is the nominee for the beneficiary.
Well, actually, no. MERS would have no authority to foreclose as nominee unless they were assigned.
I know, but okay. We're assuming that everything is done correctly. That this is the process that you would have to go through.
Right.
But look what happened. If you move over to the right, all of a sudden, there comes another trust here. It's called MALT 2004-1 trust. That's Master Adjustable Rate Mortgages Trust 2004-1. That is another pool, just like the one that we just talked about, Credit Suisse Trust. And in here, it shows the UBS Real Estate Securities as a transfer, Wells Fargo Bank as the master servicer and custodian. JP Morgan Chase is a trustee. So JP Morgan Chase was the trustee for both of these trusts.
Well, it's nice to be boss, you know. Let's just be trustee of everything in the world.
Okay. But now you go down a little bit, but look at the cutoff date, January 1st, 2004. So this note had to be in there before January 1st, if it was in there. I just happen to know that we did a loan level analysis and we did the securitization analysis and audit for this particular loan, and we found that this loan was not in this MALT 2004-1. It was in the Credit Suisse Trust, but not in this MALT here. So what they did,
JP Morgan Chase as trustee would have no authority to act because the loan was not under their care as a trust, in their trust.
In this MALT, they did have the authority for Credit Suisse,
but not
on this one
not over
here.
this loan.
Right. So the borrower defaulted, and then there was a notice of default issued on February 26, 2010 by California Reconveyance, as the trustee. And then you'll find the same date, February 26, 2010, same date, assignment of the deed of trust. It says the deed of trust was assigned to U.S. National Bank Associated, the trustee, and they were the successor interest of Wachovia Bank and trustee for 2004, which they were assigned all the beneficial interest together with the note and the security thereby. So this particular note, together with the deed of trust.
Well, wait a minute. Was the assignment recorded?
This was recorded in the county recorder's office. Here.
That U.S. National Bank Association was assigned to be trustee.
This is the exact recorded documentation summary in the recorder's office. And this was signed by Deborah Brignac, Vice President, who is also a robo-signer. How do I know that? And
well, why don't we talk about what a robo-signer is?
A robo-signer is the person who signs thousands of these things in one day without really having first-hand knowledge of the true aspects of the underlying note and the deed of trust and the default condition of the loan.
And generally it's because they claim to be vice president of U.S. National Bank, but they're also vice president of Wachovia, and they're also vice president of all these other big...
They wear many hats.
And so the position is, how can you be vice president of One West Bank and vice president of U.S. National Bank? I mean, that's like an impossibility. You're serving two masters. And apparently the robo-signers act as some high-level agent of many different financial institutions, and that's what makes them robo-signers. The fact that they sign a lot, and they also don't really have one job.
That is correct. And the other thing is, Deborah Brignac, or these robo-signers, they have no personal knowledge of the true facts of the underlying note and the deed of trust and the default processes or the condition of the default. They just sign it. Why do they do that? Is because this has to be done for the foreclosure process. And the judges buy into this.
Well, and the judges probably know about it, but still they don't do anything to bring justice, because even when the robo-signers have been caught committing perjury and testified to the fact that they lied in a deposition where they were under oath, they don't get put in jail or they don't get held in contempt of court.
That is correct. Then, the same date, substitution of the trustee, and what they did is that U.S. National Bank as the trustee, successor in Wachovia, 2004-1 by J.P. Morgan Chase, attorney in fact, signed by Deborah Brignac, the same robo-signer, vice president this time of MERS. Now she's a vice president of MERS.
She must make
right
an awful lot of money if she's vice president of MERS and U.S. National Bank.
This is the substitution of trustee, which was May 26, 2010, signed by Deborah Brignac, the same robo-signer. And then what they did, if you go over to the left, and then notice of sale, but this time what they did, they assigned the Flagstar Bank as the original lender to foreclose on this. See, we went back to the same original lender.
Because they have to.
Because they have to. But where did it come from? It came from the wrong trust. Came back to the same original lender. Could they do that? No way on earth they could do this. Now, if this goes to the court, the judges, they're not going to see the whole thing in here.
Well, the judge would have to be honest. If the judge is honest, as we've seen in many court cases where the judge is honest, and we're going to show you some evidence of that, then they hold their feet to the fire and they say, you know, you can come back if you can correct all of your errors. It's not that you can't foreclose, but you have to correct all your errors.
But the thing is, though, the documents are already recorded. The fraud has already been committed.
Yeah, right.
So are you going to come back and say, oh, I'm sorry that we made a mistake?
I'm sorry we lied and we committed fraud.
They're foreclosing on somebody's property. And when they foreclose, over 90% of the people, homeowners, they don't fight these cases. So they go to court. The judge, all they see is a notice of trustee sale, assignment of deed of trust, and then an attorney comes in, and the homeowners are usually not there, or if they file for bankruptcy, they're not going to get anywhere anyway. So these cases go through foreclosures that they don't need to be. So what do we need here? We need good lawyers, honest judges, and lawyers who really understand the processes of the securitization and possible frauds that have been committed.
Well, let's look at some court cases.
Okay.
And here's Deutsche Bank National Trust Company, and this is a case. You can see this was actually filed, right? This is a copy, of course, but this is an actual court case in the Court of Common Pleas, Claremont County, Ohio. The defendant's matter came before the court for a bench trial and a case ordered dismissed for lack of subject matter jurisdiction. Findings of fact. And we go down to the defendant, Stephen M. Feck, applied for a loan, right, to finance his house. The defendant voluntarily executed an adjustable rate promissory note. The mortgage securing payment of the note, the mortgage was recorded in the county recorder's office. Defendant Steve Feck ceased making payments on the note. Well, this is a pretty common story. Steve Feck is not currently making payments on the note. The defendants reside at the property. I mean, he's still living in it. Defendants receive mail at the property. That's important because receiving mail establishes that you're, living there and a resident. And the plaintiff, which was the bank, proceeded with presenting testimony of Christopher Spradling. Spradling is a representative of Litton Loan Servicing. Litton acted as servicer for the GSAMP Trust. Now, what do we know about that?
Well, that's the
It's a pool.
pool. That's the pool.
Right. And the securitized trust under which the plaintiff served as trustee and into which the mortgage loan at issue was allegedly placed in November 1st, 2005. Spradling testified that Litton, that's the servicer for the pool, in its role as servicer was not responsible for keeping the original loan file, presumably containing the original subject note. Now, what do we know about that? If you don't have the note and the deed together, and you can swear that they never were separated, then you have no right to foreclose. Plaintiff produced the original note and mortgage at trial. So somehow they dug up the original. By way of an allonge on the original note, the note was at some point transferred from South Star Funding, who would be what?
The originator.
The originator, who probably is on the deed of trust as the lender, by blank endorsement. What's that?
Well, this is a norm. They do this normally when they transfer, they sell the note along the securitization process. They endorse it in blank to be filled out just before foreclosure.
And the endorsement is pay to the order, and then it's just
then
blank, so you could fill in any name you wanted.
It becomes a bearer type
bond
instrument.
Now, is it illegal to change that a promissory note? Yeah, you can't add words to it. The promissory note is I promise to pay and I sign my name to it and stuff like that. The bank can't come along later and change it.
But if they sell it to somebody else, they have to.
If you're going to, the minute you put pay to the order of, it becomes a negotiable instrument, and it has value. And what's its value? If it's a $500,000 note, it's worth $500,000 the minute you put pay to the order on it.
Right.
So they would have to credit you $500,000 because it's your instrument.
Right.
And this is the real problem. The mortgage was assigned to the plaintiff by an instrument dated April 21st, 2008, and recorded at the Claremont County Recorder's Office. Conclusions of law. 1. When an instrument is endorsed in blank, it becomes payable to the bearer and may be negotiated by transfer of possession alone. In other words, if you find somebody's check that they dropped out of their pocket and it says pay to cash, you have authority to cash it.
Right.
They don't even can't even ask you your name. Back to number 2. Federal Rules of Civil Procedure 17A requires that all actions be prosecuted in the name of the real party in interest. The real party in interest is the party who has been wronged, who has suffered a loss or personal injury. 3, where a party lacks a real interest in the subject matter of the action, it lacks standing to invoke the court's jurisdiction. And then they provide the cases there. 4, the holder of rights or interest in property is a necessary part to a foreclosure action. In other words, you have to be the one with the right to foreclose. Otherwise, you can't proceed with a foreclosure action.
It's an interesting era that we're going through, but I think the truth will prevail, given the right time and perseverance on the part of the homeowners, and I think we will come out with a positive results in this.